Okay, we are live on YouTube. The meeting will start within 2 minutes. Hello, good afternoon to everyone. My name is Varun Kumar, founder of Law Audience. So before I start, I would like to make it clear that direct questions for today's meeting are not allowed. Uh, Yes. So the topic for today's discussion is understanding advocate on record system in Supreme Court of India. And today we have with us Advocate Harish A. Raichuria, sir, who is currently practicing as an advocate on record at Supreme Court of India. He also practices at various tribunals, forums, district courts, and high courts. Sir started practicing in Supreme Court in 1990. So now I request from sir, please continue with the session.
Good afternoon, everybody. It is my privilege to talk with you about the advocate on record system, which is in Supreme Court since 1950. I am also thankful to Varun Kumar for facilitating this event. The purpose of this event is a little educative, that all over India advocates practicing different courts may be knowing one thing, that if you have to file a case in Supreme Court, then you have to engage an advocate on record of Supreme Court, because he is the only person who can sign wakalatnama, who can file wakalatnama. All other advocates cannot file wakalatnama in Supreme Court. Now, this looks a little strange, because Advocate Act gives a permission that as soon as you become advocate, you can appear and argue in all courts of India. Then why in Supreme Court there is a such system called advocate on record? And who are these advocate on record? How one can become advocate on record? These general questions comes in the mind of a advocates living in different districts of India. Before we go on this, I would like to say that the purpose of this webinar is to just to give you an overview of this advocate on record examination, advocate on record system, how it works, what can be done, how can you can apply for appearing in this examination, what are the syllabus, and after you become advocate on record, what will be your problems. You see, many of you are looking for a secure job after becoming an advocate. So many things that once you become an advocate on record of Supreme Court, life will be very easy, because whoever goes to Supreme Court, either petitioner or respondent, somebody will have to hire and somebody will have to engage an advocate on record. So if you become advocate on record, you will start getting automatic cases. That may be a general idea in mind of many advocates. The purpose of this webinar is also to demolish that thought. It is not as easy as you think, that once you become advocate on record, life become easy for you. It is not so. But why, believe me, why not to understand the entire examination and how the system works. So let me begin by telling you about the importance of this advocate on record system. You see, up to some year, when a High Court judge retires, then he can practice only in the Supreme Court. He cannot appear in other courts. So he comes to Supreme Court, practices here for 2, 3, 4 years, then he goes away. Then what will happen to the cases which he has received? So we need some advocate living permanently in Delhi who can look after the case even after the High Court judge is gone. Similarly, there are senior advocates. Advocate on record permit that senior advocates can argue without filing wakalatnama. So suppose there are some cases of a senior advocates. They also need some advocate in Supreme Court who may be regularly living in Supreme Court in Delhi. So therefore also this system is necessary. Then before 1950, what must be happening before this system came? Somebody from Madras or Mumbai will come, he will file a case here and he will go away. After some years when the case will come up, there will be no one to look after the case. Therefore, some restriction was required about the advocate who can file this examination. Now, what happened in 1950 or before 1950, there was a federal court, then Supreme Court was established. Then in 1950, all advocates who were practicing in Supreme Court, they were all declared advocate on record. They were given privilege to file wakalatnama and file cases. All other have to pass through them. They have to file, they can argue, but they have to file wakalatnama and case through advocate on record. So this was in 1950. Thereafter, in 1966, rules came into force about advocate on record examination. But between these 50 and 61, there was an issue that suppose a person is registered an advocate on record in Supreme Court and he wants to file a case in Mumbai, can he do it? So there was a special law which said that an advocate on Supreme Court can file wakalatnama in any court of India. These were privileged to granted to the advocate on record that they can not only file cases in Supreme Court, but in entire India they can file case irrespective of any bar councils. But this provision act was repealed in 61. Now different bar council has their own rule about who can appear. But we come to the point about 1966 Supreme Court rules. Now these rules provided for an examination of those who want to become advocate on record. The examination were taken. A committee of judges was constituted. Senior advocate used to check the examination papers and the results were declared. Now many illustrious persons have passed this examination. For example, our President, His Excellency Ramnath Kovind, he had also passed our examination and he was also advocate on record in Supreme Court in 1978. Thereafter, what I have heard is Justice Dalvir Bhandari was also a lawyer in Supreme Court. Probably he also was advocate on record. Then he became High Court judge and then judge of the International Court of Justice at Hague also. Then I remember Ranjit Kumar, former Solicitor General of India. He had also passed advocate on record examination. He was a OR. Then we can refer to the our present Supreme Court Judge, Justice Uday Lalit. He had also passed AOR, Advocate on Record examination. He was AOR, then he became senior advocate, and now he is a judge in the Supreme Court. So this is a very prestigious examination. To prepare for this examination, to sit in this examination itself, everything gives a lot of knowledge about the constitutional law, about the practice of Supreme Court, and so many other things. It may be an exam tougher than even ICS exam, Indian Administrative Exam. These exams could be even more tough, Supreme Court Advocate on Record examination. I passed this exam in 1992 at first attempt. So at that time also many advocates were failing in the exam, and result was hardly about 10 advocates used to pass this exam. This was the time when I passed the exam. Now, I tell you something about me, that I didn't directly come from the law college to Supreme Court and start appearing in this exam and becoming advocate. No. I had started practice in a district court in Junagadh in 1986. There I practiced at district level for 4 years. Then I moved to Gujarat High Court at Ahmedabad. There also I practiced for 4 years. I did constitutional cases like writ petitions, civil cases, criminal cases. After all this knowledge, I shifted to Supreme Court. Here also I practiced for 2 years. And thereafter I gave exam. There was a requirement that an advocate should take training under an advocate on record of 10 years ending for 1 year, then only he can appear in this exam. In my case, I did not take any training under any advocate on record. There I saw a rule that Supreme Court can grant exemption from training to suitable candidates. So I made an application that, look, sir, I have been practicing in district court, high court, and as well as in 2 years in Supreme Court. So I already know most of the procedures of Supreme Court, High Court, and the trial court. So I should not be compelled to take training under an advocate on record. I should be given exemption, and I should be allowed to directly appear in exam. The examination committee of the Supreme Court considered my application and granted me exemption. So I become eligible to appear in exam without undergoing 1 year training under any advocate on record. Today also these rules is there, but in rare cases this exemption is granted. Most probably those who want to appear in this exam should be prepared to take 1 year training under an advocate on record. Now in 1992, many advocates were failing in the exam. The reason was there was an examination of accountancy and bookkeeping. Now, most advocates were not so well versed with the accountancy and double entry bookkeeping, these bank reconciliation statement, interest and income tax type things, and bookkeeping points. And then most of them used to fail in the accountancy paper. I had a commerce background. Was a commerce graduate. So accountancy was very easy for me. So I could pass this exam in the first attempt because accountancy paper was not very difficult for me. So in 1966, this was the requirement. Advocates should have 7 year practice, plus he should take 1 year training. Then only he can appear in the exam, and he has to face accountancy paper also. Thereafter, in 2011, someone filed a case in Supreme Court stating that look, now we are hiring chartered accountants for managing our accounts. Why do you insist that we should know accountancy? Many are coming to arts stream, science stream. Why all of them should learn accountancy and everything? So Supreme Court allowed the petition and said from this onward, accountancy paper will not be asked in the examination. So then Supreme Court rules were again framed in 2013. Now here one another change was made. Some advocates complained that 7 years is too much. Please reduce it to some less. So it was reduced to 4 years. At presently, this 2013 rule are operating. So advocates should have an experience of advocacy for 4 years plus 1 year training under an advocate on record. Then he can appear in this advocate on record examination. These are the present requirement. About after you become an advocate on record, there have been instances also that from advocate on record, suitable person has found place as a high court judge. Some has become senior advocate. So advocate on record appearing in this exam is prestigious. To pass this exam is prestigious. And it is really a very tough examination. Though accountancy paper is not there, but even the other papers are there. There are 4 other papers which you have to clear in this examination. For example, in law college, you may have learned several civil procedure code, criminal procedure, everything. But what about Supreme Court practice and procedure? Supreme Court procedures are conducted as per the Supreme Court rules 2013. Different steps are required to be taken in registry. There is a certain format of filing special leave petition, writ petition. There are several rules and guidelines. So Supreme Court needed that one who becomes advocate on record should be very well versed about Supreme Court practice and procedure. So one examination taken is in practice and procedure. Second examination is taking is about drafting. That how your drafting skills are there, because Supreme Court matters are differently drafted. In High Court, when you file a Article 226 writ petition, it is original jurisdiction. You can simply state your case. But in Supreme Court, judges have to check what are the error in the findings of trial court judgment, what are error in the first appellate court judgment, what are the errors in the High Court judgment. You have to study these errors and then draft accordingly. So some sort of skill was required for drafting matters in Supreme Court. So Supreme Court said, let there be a question paper on this also, that let us see how you can draft a matter in Supreme Court. Do you have proper understanding of findings, conclusion, which appears in the judgment of trial court, high court, which evidence are important, crucial, what points are crucial for Supreme Court. So drafting paper is there. Then there is an advocacy and ethics examination. The Supreme Court judges have a vision that advocates in Supreme Court should be like a role model for the other advocates of the country. They should be very high in the ethics, and they should know what is misconduct, what they should do, what they should not do. Here you see cases of crores and crores rupees come. This is a last court. Sometimes $1 billion, $1 trillion cases come. For example, WhatsApp cases, Facebook cases. So integrity of advocate is very important. So Supreme Court said, let us take an examination about the ethics and uh, Advocates Act. For example, I remember one question was asked to me that as an advocate on record, you have engaged a senior advocate. Now case is over, senior advocate has sent you a bill for his fees, but the client has gone away and he is not paying you anything. Then what will you do? I replied in my answer sheet that I will pay the senior advocate's fee from my own pocket. You see, my answer was very correct. Advocate on record rule says that all amounts payable to the court, for example, suppose court imposes fine of a 25 lakhs to a client, litigant. If litigant doesn't pay, then what? There are procedure for recovering it from the client, but advocate on record is primarily responsible to pay all the court fees, all the amount is personal liability of advocate on record. He cannot say, no, I don't know. I am advocate on record only, you go after the client. For example, I cannot say to the senior advocate, look, you have sent me bill, but my client has gone, you go after that client and you file case in the Delhi court to recover the fees. That is not good for the advocate on record. Advocate on record should see that when he engages senior advocate's fees are to be paid. Advocate on record is personally liable to pay the fees of a senior advocate. Senior advocate gives bill in the name of advocate on record. So for example, suppose you send me a case, you send me instruction to engage certain senior advocate, I engage and case is lost. Senior advocate sends you bill and I send you the bill, but you refuse to pay it bill. Then it is my duty to pay the senior advocate's bill. This is how the responsibility of advocate on record is there. Court knows only advocate on record. Senior advocates know only advocate on record. Registry know only advocate on record who are registered. They are answerable to everything in the Supreme Court. So that's why advocacy and ethics examination is taken. Very typical questions and testing questions are asked so that judges can actually gauge how much integrity is there in you. If they doubt your integrity, you may fail in the exam, even if you may have scored very high mark on everything. Then comes the last very difficult paper. It is about leading cases of Supreme Court. Now, what is difficulty about this question paper? You see, there is no advance information to you about which will be the leading cases which you have to prepare. Information will come only at the time of notification of exam will be issued. For example, if today notification is issued that after 2 months exam will be taken, then only today Supreme Court will inform you that there is a list of leading cases you should study. And from this, we will ask you a question. Now, if you will look at the list, the total number of judgments pages will go beyond 2000, 3000, 4000 pages. In 2 months, you will not be able to prepare, even read these leading cases once. So here is the screening test. Those who are actually practicing Supreme Court, they already know what kind of leading cases are being discussed in Supreme Court, what are the points involved. They will not have to read 4000 pages in 2 months. They will be already know, oh, this case I know, this is about this is about this. So here is the screening actually happens. Suppose you are not regularly practicing Supreme Court, you stay in some hostel and keep studying all these other three papers for 3 years and pass on all the 3 years. But what about the leading cases paper? Only 2 months you are given to study the paper, exam leading cases, and you are not regularly appearing in Supreme Court, so you do not know what are the criteria, ratio, how the judgments are to be understood. So here is the clutch. If you are practicing in Supreme Court, then it is easy to pass this examination. Otherwise, it is a tough thing. Now, this webinar is not about how to prepare for an advocate on record examination. It is also not about discussing where to get books for this examination, what will the syllabus. I can only say one thing, that Supreme Court Rules 2013 is the everything, contains everything in this. Even syllabus of the exam, the question papers, details, all rules, regulation regarding advocate on exam examination are in this Supreme Court Rules 2013. There you can get so many answers. In fact, earlier also Varun Kumar and I had done a webinar on how to prepare for advocate on record examination. It may be video available on YouTube. And actually, maybe some more videos are necessary for preparing. But let me think about your perspective, that you are, I assume that you are someone in Gujarat, someone in Mumbai, someone in Kerala who is listening to this webinar. You only want to know how will I pass the examination, and if I will pass examination, what will be my income? Will I get lot of money, as it is discussed in the newspaper that senior advocates are charging so many lakhs of rupees? So will I become very, very rich if I become Supreme Court advocate on record? And it is said that everyone has to engage an advocate on record. So will it be very easy for me to practice? Because any party who comes to Supreme Court will either petition or respondent. Somebody will have to engage an advocate on record. So I will have a income without making much effort. Is this a right concept? In my view, this is not a right concept. It is not a very easy that way. Let me explain how the environment is here. In 90, I shifted to practice in Supreme Court. There was some compelling reason for which I wanted to leave Gujarat High Court and I wanted to shift to Supreme Court. There were some compelling reason. So it was not an ambition or something, but I had to shift away from Gujarat High Court. So I, my wife, and my 1 year child, we came here Delhi only to see the Supreme Court. We moved around in Supreme Court for about 2-3 hours. Then we sat in the garden. We wandered in Delhi. Nobody knows us. There are no relatives, and I didn't know even other Gujarati lawyers in Supreme Court. So will I survive here? I discuss with some advocates. So what is going on in Supreme Court? And one thing encouraged me was this: that 1 month before that, I had come to argue a case in Supreme Court before a bench of Justice M.N. Venkat Challaiah and Justice P.B. Sawant. Justice P.B. Sawant just passed away last week. I had come with a case from Ahmedabad, and judges listened to me for about 2 hours. It was an interesting case. Someday I will discuss it. And in the middle of the arguments, Justice Sawant uh, cautioned me. He said, "Mr. Counsel, please lower your voice. Your voice is hearing up to Ahmedabad." Now, this comment is required in this way that in High Court, we argue with our passion, we shout at other advocates, we speak at the top of our voice. But in Supreme Court, there is a different system. You have to be humble, submission should be humble, voice should be humble, and you are appearing before the king. Supreme Court judges are called lords because after them there is only God. If they dismiss your case, then only God can help you. Even writing to President of India will not help you. So when you are appearing before an authority which is next to God, you have to be very humble and proper and must behave according to the authority with which you are appearing. So in that time I didn't know. I was shouting just in the High Court style. I ultimately succeeded also in the case. That was encouragement. So when we are sitting in the park of Supreme Court, we discussed that if the judges listen to me for 2 hours, then there is nothing wrong in my argument skill. I can sit here and I can argue here. Then we decided and shifted here. And after we shifted here, we began to realize very difficulty which are here. So now I am going to tell you that suppose if you shift to practice in Supreme Court, what kind of difficulties you may be facing. The first and foremost difficulty will be about the competition. You see, there are 7 types of advocates practicing in Supreme Court. If you have pen and paper, you can start noting down. It is a very, very competitive place. First, there are 2,500 advocates on records in Supreme Court. Mind you, last year filing was about 30,000 cases in Supreme Court. Now, if you calculate how each advocate may be getting, so an advocate on record may be getting about 10 cases per year, means less than 1 cases in a month. And there may be big shark, small fishes. Some advocate on record may be uh, cornering the corporate sector, tax sector. They may have very big offices, several juniors, and they may be getting a lot. And there may be other side of advocate on records who may be starving for the cases. They may not have any income. When I came to Supreme Court in 90, I saw an advocate on record. He used to come in a public transport bus every day in Supreme Court. He used to sit in a sofa in lounge, bar room, and he used to sign file cases of others for 200 rupees only. Though there were 200 rupees signing charge of advocate on record, I used to pay 500 rupees to an advocate on record who was suffering from Parkinson disease. I thought that it will help him also. So everything was being prepared by me. I was filing, I was arguing. Only signature of advocate on record was required. And so I was doing. Now, this in the 2013 rule, this is considered a misconduct. If an advocate on record simply gives his signature to somebody and does not do anything about the case, then it will be a misconduct. His name can be removed from the role of advocate. So now, when you have to file a case, the advocate on record will have to check your case. He will have to do something in the case so that it does not appear that it is simply a name lending case, name lending advocate on record. So there are 2,500 advocate on records at present. Then there are large number of senior advocates. Now senior advocates are not supposed to entertain clients and the clients call directly, but that standard have now fallen by some senior advocates. They directly receive phones from their high court, they receive paper at their home, they prepare matter, then they ask some advocate record or some junior advocate who may be sitting in the chamber to file in the case. So these senior advocates are also not as per their ideal standard. If their ideal standard, the ideal standard was this, the senior advocate will not talk with anyone except to advocate on record. And he can be engaged only through advocate on record. That was the high standard prevailing here when I came, maybe up to 95 or so. Thereafter, the standards started deteriorating. So they are also in competition. Some senior advocates are there. Then when I come, high court judges, when they retired, they used to come and practice here. So when a high court judge, retired high court judge comes from a high court, then he may have many friends in senior advocates and others who will start sending brief to them. So that's why the advocate on record do not grow up. Within 2-3 years, another high court judge will come and so on. High court judges were getting more cases. But this thing changed after the Arbitration Act came. After the Arbitration Act came, the retired High Court judges began to get many cases of arbitration. So now very few are willing to come to practice in Supreme Court. So we can say that now High Court judges are not competition. But then there are other advocate on records. They are called non-advocate on record. They have not passed exam, but they still appear and argue in Supreme Court. They take cases for Supreme Court. Some of them are less than 1 year standing. As soon as they come out from the law college, they said, I am Supreme Court advocate, I am appearing in Supreme Court, I am arguing in Supreme Court, I am filing in Supreme Court. Now, this was a not so appreciable thing. So in 2013 rule, a minimum 1 year rule is made that after a person become advocate, for 1 year he cannot argue in Supreme Court. If at all he is required, he can mention about adjournment or something like that, but he is not prevented from arguing for 1 year. But then these advocates, many who had ambition to become AOR, they shifted here. They had some parents in High Court who were sending them brief. So they settled here in Supreme Court even if they are no AOR. And they also practice in Supreme Court. They are also in competition. They have fathers, uncles, some in High Court. So they get briefs from them. Then there are advocate on records who are partly in Delhi and partly in their hometown. For 15 days they will stay in Supreme Court, and for 15 days they will sit in Ahmedabad, Mumbai, Chennai, Bangalore. There they will, for 15 days, they will collect the briefs directly from the clients, prepare cases, file it online, or will come. So they are advocate on record who are, let us say, non-resident advocate on records. Rule says that they should have an office within 16 kilometers of Supreme Court, but they somehow manage to associate with somebody and then keep traveling to different uh, metro cities only for the purpose of collecting brief. So they are also in competition. Now the biggest competition you have here is all the advocates of Delhi, Tijari Court, Saket Court. There are 9 districts in Delhi. All advocates will say that yes, we are Supreme Court advocate. They will take Supreme Court briefs. They will come here, engage an advocate on record, give him some signing fees, and they will argue and they will go away. So this is the tough situation of competition here. The purpose of this discussion was to dispel a belief from your mind that as soon as you will pass advocate on record examination, your life will be secured. You will get cases either from petitioner or from respondent. It is not so. There are 2,500 advocate on record at present, and I already gave you number of cases which are being filed. So the what you read in papers that there are some senior advocates who take every day 1 crore 75 lakhs every day income, but they are a class apart. You cannot compare yourself with Kapil Sibal, Mukul Rohtgi, or other senior advocate. They have their own knowledge plus background. Background word is very important. Some people have a background of Mumbai. Mumbai is considered very high paying. Calcutta is paying high paying fees. Then Chennai is paying high paying fees. Kerala is paying high. But suppose you are from Bihar, then your client in Bihar will not be paying much. Suppose you are from Haryana, then you will not get much fee because of the areas of in UP there is very standard of fees is very low. A advocate on record told me few days ago that in Uttar Pradesh, Allahabad High Court, they say that Supreme Court met advocates fees 2,000 rupees per case. In 2,000 or say 3-4,000, you can do a case in Supreme Court. So different city-wise income distribution is there. If you are in Bombay, then yes, you have a good chance in Supreme Court because the background, the clients who will send you brief will give you sufficient income so that you can survive in Delhi. In Delhi, suppose you stay here today with your family, you put your children in the Delhi schools, you rent or buy a house in Delhi, your monthly expenses will be about 1 lakh rupees if you live moderately. When I came to Delhi in 1992-90, I didn't have money to pay rent of Delhi. I inquired in various Delhi house. I wanted minimum 2-room kitchen set, but the rent was higher than I can afford. I had come with money which can help me to survive for 6 months. So rent part, I could not afford rent of Delhi. So I went to Ghaziabad. Ghaziabad within my capacity in 1,000 rupees per month, I got a 2 bedroom, a drawing room, kitchen type house. And every day at 7 o'clock, I used to start from Ghaziabad to come to Delhi. At 9 o'clock, I will come to Supreme Court. At 5 o'clock, I will leave Supreme Court and will reach Ghaziabad at 8 o'clock. The rent at that time, my condition was this, that I could not find within my rent range any house in Delhi. So now you are planning to shift to practice in Supreme Court. Take an idea about the current rate of rent which is appearing and the competition you examine. Then think about who will send you brief, and thereafter you think. You see, you are if you are young, you will like to disobey my overrule my advice. You will say, I have very bright talent. I am from National Law University. I have got high scores and I will nothing less than Mukul Rothgi. Very well. You see, when in 90, when I came to Supreme Court, I took advice of several seniors in Gujarat High Court. All of them said, you don't go there. It is not advisable. Supreme Court practice is a discretionary practice. You will also lose your charm of practicing in High Court. In High Court, you can argue 1 hour. In some matter, I had argued for 3 days. They said all your arguing skill will be lost if you shift to Supreme Court. Here, the judges decide admission stage in 1 minute, 30 seconds, 2 minutes. So, how much your argument skill will be disappear. You will learn to argue in a discretionary court. So everybody advised, no, you should not go to Supreme Court. I said I will go because I was young, and there is a English word also called rectance. When somebody is giving us some good advice, rectance appear from us. It is an emotion. It says, who are you to say me? Who are you? I will decide my own future. That rectance feeling is there in young age. So I do not mind if you do not believe in my advice. My advice is that first you practice in district court, high court, and then you gradually come to Supreme Court. And in fact, on Google, you can find a uh, article and interview by C.A. Story. It is about me, my journey, how I shifted from district court Junagadh to Supreme Court in 10 years. There I have discussed step by step how I moved, how I built up my reference basis. So today, what is my reference basis? You see, today since 28 years I am in Supreme Court. All the person who have succeeded in through me are my referring agents. All those who cases have been dismissed, they also refer me cases because they find that my drafting is good and my advice is correct and my presentation is good. So even if their cases are dismissed, they refer me cases. Then my friends in Junagadh District Court, Amreli District Court, there were 5 districts from which I was getting cases in High Court. So all those contacts are still alive. They still refer me cases. Then all my friends in Gujarat High Court. When I shifted to Supreme Court, I gave an ice cream party to entire Gujarat High Court bar. So everybody noticed that why this ice cream is coming. Because Mr. Raichura is going to practice in Supreme Court. Therefore, this ice cream is being served to everybody. So there were my friends in Gujarat High Court. They still refer me cases. They were junior advocates. They are junior advocates. They have little work, but they send me briefs. And you see, what did I tell them when I shifted? I said, you refer me only those cases where client do not mind dismissing. For 2 years, I will keep learning to argue in Supreme Court, and most probably all my cases will be dismissed. So only those who want their cases to be dismissed should refer me cases. That was my frank and fair talk with my friends in Ahmedabad. They appreciated my frankness. Whenever they have such a client who had little capacity and who do not mind losing in Supreme Court, they started referring me those cases, and that's why slowly after 2 years I picked up. I found out how the what Supreme Court judges are looking in a case, how could I present those things, and how could I get orders. That by 2 years I had learned this. So this was my frankness. What I wanted to say is, and now what I wanted to say you is, you consider this whole aspect. This webinar subject was understanding the advocate on record system in Supreme Court. I have pointed out this system is going to stay here because senior advocates can't file wakalatnama, high court judges can't file wakalatnama, advocates from Bombay will have to go to Bombay again after arguing here. So some advocate in Delhi are necessary. So advocate on record system is necessary. It will stay here. Now rule says that examination will be taken uh, twice in a year. But you see, since some years, this year the exam was also cancelled. Then earlier it was decided only one exam in 1 year. You see, there the judges are also looking. Simply passing advocate on record is not, they should be getting briefs. Advocate on record should be from every state of India. Suppose in the merit list, all 200 advocates of Delhi have crossed very high mark. That does not mean that 200 will become advocate on record. It means Delhi Supreme Court is monopolized by Delhi court advocates. That is not the way judges look at it. Judges want representation of Tamil Nadu, Kerala, every high court's lawyers should be here. That is how they examine the paper, they reevaluate the paper, they moderate their system. It is not like an academic examination. So, if you have ambition to become advocate on record of Supreme Court, I have nothing wrong. In fact, within the first month of I joined in advocate on record, I remember that I was standing near an cupboard. I had took up a SCR volume and I was reading while standing before the cupboard. I was reading Justice P.N. Bhagwati's judgment, and then this thought came to me that if in district court I do work, suppose I have done good work, then beneficiary will be only two person, my client and dependent. But if I practice in Supreme Court, suppose I get a good judgment, thousand people will get benefit. If I burn midnight oil, I develop some interesting point of law, and if that point of law is accepted by Supreme Court in a reported judgment, then you imagine lakhs of people in India will get benefit. That thought came to me in 1982 when I was hardly a 1 month old advocate. So I do not find any fault if you have an ambition to practice in Supreme Court. First of all, you get in touch with not me, but some very good advocate on record in Supreme Court. Whenever you have a case in Supreme Court, to refer a case in Supreme Court, or you want to file a case, and you talk with this advocate who have experience, he will guide you what papers are requirement, what you should take grounds, how you should submit in Supreme Court. That is what is the function of an advocate on record. He has to guide other advocates who want to file cases in Supreme Court. Sometimes I have to guide even senior advocates. I remember a judge of High Court and Tribunal came to practice in Supreme Court. When they file case through me, they ask me, look, they feel very much pride in their first cases that in 1 minute, how will I say? They may be a judge, but they will not know how to submit before the court. So I guided them, you point out these are point first, then you take second point, and even if they disbelieve, then you get this order. These orders they will give you. That I used to guide even the High Court judges and the Income Tax Tribunal judges, other judges who came to practice here in Supreme Court. So it is the basic function of a senior advocate on record to guide the advocates who are coming to Supreme Court. Now, name lending advocate on record is a very evil thing. I consider it evil. But then I imagine the advocate on record whom I had seen in 92. He was coming in public transport. His only source of survival was name lending. For 200 rupees, he will sign a case. Now, suppose if you treat this as a misconduct and you remove him from advocate on record, then his livelihood will go. Now, think about the advocate on record was suffering from Parkinson disease. He was disabled except sign, he could not do much. Now, his young age, he spent in Supreme Court. He argued case drafted. Now in old age, he has become disabled. Only he can do is signing the case. Now, if you treat this as a misconduct, that signing someone's case is a misconduct, then this man also will go. When this thought comes to me, I no more feel that signing somebody's case for 500 rupees is bad. Some advocate on record are in badly need of signing cases because I had just given you a figure that there are 2,500 advocate on record. Some of them are coming, some of them are not coming. Let me give you example of my own junior who passed advocate on record examination in last examination. It is about 8 months now. He has not get a single case even for the signing or for filing. Last week a case came to him, but he said, "Sir, you do everything. I am still not confident." He passed the drafting paper in Supreme Court, but still he said, "I won't be able to draft this map. Some guidance is needed." So I guided him in everything. So suppose you have passed drafting paper in your exam, that does not mean that you will know the drafting. You must consult an advocate on record with experience. He will say you what points should be heard first, what should be next. This is how the advocate on record system works. I think this is all which I can say. If there is any question, Arun Kumar can say.
Yes, sir. There are total three questions, and only one is related to today's webinar. So I will ask that. The question is from Anish Antonius sir from Kerala High Court. How feasible for non-advocate on record advocates can file cases through advocate on records and appear and argue the case?
I think that is the very right thing. Actually, I also didn't want to become an advocate record. I wanted to remain in such that I will get my best free, my briefs, I will argue, and I will remain free. That was the right way. Once you become advocate on record, you become tied down with the Supreme Court. So best way is to engage some advocate on record, and there is no problem. Suppose if you get an advocate on record who is not covetous, means he is not looking after taking away your client, then you are in good hands. You see what I did when I came here. I was also very much afraid that if I will get some advocate on record who will take away my client also, then what will I do? So I preferred an old aged advocate on record. Dr. I.B. Gore was my advocate on first advocate on record. He was a aged person, he was a retired person. So I had no fear that he will ever take away my clients or my advocates. So you should get an advocate on record whom you trust that he will not touch your client. He will not talk with your client. He will not act against your interest. That type of advocate on record, if you can get, then it is a good idea to file for advocate on record and argue case. But there is one thing which I must tell you. So far as companies are concerned, they want to know the name of advocate on record. If they find that the advocate on record name is good, then only they give you brief. So here the passing of this examination is comes into play. After I became advocate on record, I got cases from Nirma, Arvind Mill, and other companies also. Companies like to see that the advocate whom they are engaging with the entire brief is advocate also. But apart from the companies, other clients do not insist that you need to pass AOR exam and you are advocate on record. So this is the answer. It is okay. You can file through some AOR, get a good AOR whom you can trust.
Yes, sir, that was the only question for today's webinar. Okay, so there is one more question from Naved Pathan. Sir, drafting skills are different than High Court and trial court in Supreme Court.
I think drafting skill is very different. Uh, I tell you why reason. Suppose you are drafting an Article 226 writ petition, then judge will not find any fault with what you are saying. You have to state your case. Whatever way you want, you state, this is my case. This is how my article is violated. That's all. And 50% cases you will get notice. But when you are drafting an appeal, Supreme Court matters are coming under Article 136. They are appeals. Appeals means you have to prepare a ground on by which reason you say that High Court judge has committed error, by what reason you say that appellate court has committed reason, by what reason you say that trial court has committed reason, how you say that this is different than settled law of Supreme Court. So this type of drafting is required in the Supreme Court. It is not a normal drafting as in the Article 226 petition. So this is how the drafting skill is there. But best thing is if you find if you are interested in practicing in Supreme Court, then first thing you should do is to buy Supreme Court Rules 2013. Then there is a book of Raju Ramchandran, senior advocate. He was also an advocate on record. He has written a book called Supreme Court Practice and Procedure. Then there may be other books also about the practice and procedure. But this is the basic book. Supreme Court Rules is the basic book. Everybody has written in this. And there is one thing which you should study is in Supreme Court Digest, study all cases which are listed under Article 36, 136. Almost 90% cases filed in Supreme Court, 99% cases filed in Supreme Court are under Article 136. Now, SCC Digest contains a separate section about cases under Article 136, when Supreme Court will interfere, when it will not interfere. It will give examples and citation. So that you should study. In that way, you can succeed in the Supreme Court.
Yes, sir. So there is no new question. So if you allow, we can end the session.
Thank you, all of you. Best wishes to all of you.
Yes, thank you, sir. Thank you very much for your valuable time, and thank you to all the participants for